Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself, and finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is Collado versus Delon Real Estate, a pending case in New York State Supreme Court, Kings County. So first, let's set the stage with some context. This will be the first time on this pod that we're covering a case that is pending. The case is not finished yet. We do not know who is going to win this case. It's still in court. I came across the case when I was doing a litigation search for a client of mine. Today's case concerns Real Property Law 227E, which requires a landlord to mitigate damages caused when a residential tenant breaks a lease early. In episode 20, we covered Real Property Law 227E. That episode was entitled, "If I break my lease early, does my landlord have to try and find a new tenant, or am I on the hook for the rent through the end of the lease term?" You might want to listen to that episode later because it'll give you some more basic information on this important topic. Before Real Property Law 227E, tenants had very few protections when they broke their lease early. And then we got Real Property Law 227E in June of 2019. So now I'm going to sort of paraphrase the statute very quickly. So if a tenant vacates a premises in violation of the terms of the lease, the landlord shall, in good faith and according to the landlord's resources and abilities, take reasonable and customary actions to rent the apartment. If landlord rents the premises at fair market value or at the rate agreed to during the term of the tenancy, the new tenant's lease shall, once in effect, terminate the previous tenant's lease and mitigate damages otherwise recoverable against the previous tenant because of such tenant breaking the lease. In other words, residential landlords in New York State have a duty to attempt to mitigate, to lessen damages when there is a lease break. The landlord cannot just sit around and do nothing and keep charging the tenant for a vacant apartment. The landlord must at least try to find a new tenant. That's the context you need. Now let's get into today's case. Today's case is so interesting. As I said, it's a pending case. It's still going on. We do not know yet who is going to win. Plaintiff is a tenant who broke his lease with 9 or 10 months left on it. Before he broke the lease, he tried to make a deal with his landlord to be set free with no further liability. The landlord presented the tenant with 3 choices. That's not exactly clear if it was 3 choices. The factual record hasn't really been developed yet, but it was, let's go with 3 choices for now. 1, the tenant could make a deal with the landlord to pay 2 months' rent as a lease break fee, and be forgiven all other possible future liability. 2, the tenant could sublet the premises and pay a $500 sublet fee. And 3, whether the landlord said it or not, the tenant had the obvious alternative of vacating and hoping that the landlord mitigated quickly, re-rented quickly. The tenant chose to pay the 2 months in exchange for being forgiven of any prospective liability over the next 9 or 10 months. Hindsight is 20/20, and it turns out that the tenant may have been better off if they had just left and waited, because the complaint alleges that landlord found a new tenant 2 weeks later for an even higher rent than the lease-breaking tenant was paying. So tenants' damages would have been, or literally were, immediately and completely mitigated. The landlord would not have been able to chase the tenant for anything. Tenant is suing landlord, saying that the lease break fee is a violation of real property law 227E. So that's what we're concerned with today. The case is doing some other things as well, but what we're basically concerned with is the part of the case that concerns whether or not a lease break fee is a violation of real property law 227E. Landlord made a motion to dismiss, and I'll put a link in the show notes to the tenant's complaint and to the landlord's memorandum of law in support of the motion to dismiss. I'm going to now paraphrase what landlord's motion is doing. It's doing a lot of other things, but again, we're concerned with this 227E and lease break stuff. So the landlord says, 227E does not mean that you can just break your lease and automatically have no liability. It's a statute that requires the landlord to attempt to mitigate. Landlord's duty to mitigate merely furnishes a defaulting tenant with a better chance of reduced monetary damages. In such situations where tenants have potential liability, surrender agreements fixing damages are very typical and are, in fact, favored by the courts. The courts would rather the parties settle it as long as the settlement doesn't violate any statute than litigate the whole case to the end. And nothing in 227E seems to suggest that landlords and tenants are not free to continue to make their own deals in the event of a lease break or an anticipated lease break. The landlord concludes that the 2-month lease break fee does not violate real property law 227E. The tenant hasn't put their papers in opposition to this motion in yet, and I see that the case is not scheduled to be in court again until November 2024. Who's going to win? Let's look at that in the tenant takeaway section. First, housekeeping. This is not legal advice. I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it's terrible, because I am asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. If you like our work, please award us with the 5 stars and put this podcast on your socials. It's time for the tenant takeaway. So who's going to win? Well, my crystal ball is broken, and if it was working, I'd probably be in Las Vegas and not here recording a podcast. I must admit, the landlord had me there for a minute with their brief because, of course, 227E does not automatically eliminate liability. It just lessens the chance that tenant is going to have any liability. So there's still vulnerability there for the tenant. And in those situations, most of the time, people make deals. Deals are good if they give you finality, if they give you certainty, and if it's a price that you can handle. So there's nothing about 227E that suggests that a landlord and a tenant can't make a deal to eliminate the tenant's possible future liability. What comes to mind for me is perhaps 227E should have included a duty for landlord to inform the tenant of 227E. I don't see an affirmative obligation to inform tenant that landlord has a duty to mitigate. And as we explored in episode 20, most landlords do mitigate as quickly as possible for as much rent as possible. You have to understand, landlords don't get rich on lease-breaking tenants. They get rich on tenants who stick around and pay their rent. A landlord has much more incentive to look for the next tenant, and this was true even before 227E. They have much more incentive to look for the next tenant and much less incentive to pay lawyers and collection agencies to chase around lease breakers. The real problem, it seems to me, is that the public doesn't understand this. That's why when a managing agent says to a tenant desperate to get out of 9 months of possible liability so they can go do something else with their life, that they can be set free for a mere 2 months, that sounds really good. And there is some risk there, and it might be a good choice. But if you don't know about the landlord's duty to mitigate, then it might sound like a much better choice than it actually is. So maybe the landlord is doing something wrong here, but maybe it's not a 227E wrong. Maybe it's a deceptive business practice, which is not my area of law. All I know is that this type of thing affects a lot of people. It affects a lot of landlords, but by and large, it affects far more tenants. So we're going to keep our eye on this case as it progresses through the courts. And there's just never a dull moment in New York City landlord and tenant law. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.